let's go. So what we're going to be dealing with this morning, we're going to be looking at what we came to call the Octopus Act that was promulgated in December, its impact on the non-profit organization directorate, voluntary associations, NPCs, and trusts. As I've said, the latest NPO regulations have just dropped, and we're going to throw in an update, and some, you heard it first here, tax updates on 18A as well for good value. All right, so let's just take a little step back into the ancient history of last year and the response which was required of our government from the Financial Action Task Force. This is an international policy-making body which tries to limit global money laundering and terrorist financing. And in order to do that, they impose certain sorts of standards and they issue recommendations, and then they go and have a look at countries and see how well we are or are not doing. Right. You might know, it's no spoiler alert to tell you that the grey listing, everybody was putting a whole lot of effort into trying to avoid by passing this legislation at the end of last year, in fact, did happen to us. However, the work is not in vain, as there have been countries who have very quickly got out of the grey listing status. And so all of the work that we have done, hopefully will go towards that measure in the shorter and not the medium term. Okay, so the reason we call this the Octopus Bill, the Octopus Act, is because it had its tentacles in so many places. And 5 different acts being amended. So it was a general laws amendment bill, now a general laws amendment act that said there's this big thing we want to do, and therefore this act, this act, this act, this act, and this act, all 5 of them need to line up, right? And as you can imagine, the consultative process, because now you've got different departments and a provincial and a central level and the different pieces of legislation going through different sorts of government departments and authorities. So it was large. The main things that were set out in that initial bill that was issued was a wish or an intent to expose what the FATF calls the beneficial owners. Beneficial owners sits a bit uncomfortably with non-profits because non-profits aren't owned. But what they are meaning is people who are ultimately in control of all companies and organizations all over the world. So yes, the world has adapted these lovely things called companies, which shield our boards and our shareholders and our members from any personal liability. But yes, the other thing is that those organizations allow people to, in fact, hide behind, and especially when complex structures are put up with companies opening companies. So that's the idea, is that in order to highlight where money is moving that it shouldn't be and for nefarious ends, we need to see who are the actual people, peel back the layers. In order to achieve this, the first draft of that bill actually went ahead with a big old paintbrush and made NPO registration compulsory for every single organization in the whole of South Africa. More on that later. They also, in terms of these bills, added to the lists, and the various pieces of legislation had some lists of the kinds of people who couldn't serve on boards. The NPO, some of them very short lists. The Companies Act, very, very long list. The NPO Act lacked any sort of list at all. Those have now been standardized. So that's a good thing. All right. So then just to give you a brief little bit of background in case, and there are lots of people who this big picture in terms of what we were looking at. So if we look at the nonprofit sector, and you're all part of nonprofit organizations, NGOs, so you should know where you fit in this. But unfortunately, people drafting the legislation didn't quite have this big picture, which is what we had to look at with them. You have voluntary associations, you have charitable trusts, and you've got nonprofit companies or external nonprofit companies. None of these can be owned. They all exist for a purpose and not for profit. Any of these can apply for NPO status with DSD. So there's a major misunderstanding in the sector where people think that an NPO is a kind of legal entity. It is not. It is an additional status which any one of these types of legal entities can apply for. And it can apply for tax exempt status with SARS. Okay. I think when the regulations and the act were first put out, the main area of concern would have been the voluntary associations, because there's no innate requirement for registration of those. Now, when we made the submissions to Parliament and the parliamentary committees and the provincial committees, we did put in front of them an example, because I think they didn't realize when they said everybody has to register the extent of what would occur. And so we showed them visual depictions and all sorts of things about how there are so many types of nonprofits all over South Africa and at various levels of capacity, and some of them very small, and that this kind of broad brush approach would not only not achieve the purpose for which it was intended, but it would probably also break the already not in good state NPO directorate in the process. In terms of that main submission that we made, we were heard, and the switch between the first iteration of the bill and the final act that was issued is that non-profit organization registration is no longer compulsory for all organizations, and instead they have switched to, as we suggested to them, a more focused risk-based approach. So what we did was we took them in those sessions and submissions back to the actual FATF functional definition of non-profits that could be engaged in risky behavior, and we said let's rather focus on those ones, and we were heard on that. And in the act, which was issued in December, it is only now non-profits that are conducting activities or funding projects outside of South Africa's borders that are required to register with the Non-Profit Organisations Directorate. The rest, any other sort of organisation that is not operating or funding cross-border, may continue to register voluntarily if they so wish. Okay, so main changes, just a little summary here, is that NPO registration is now compulsory for some sorts of organizations, depending on where they work. There is an updated list of disqualified persons, which applies across all the types of legal entities. And when we say disqualified, it means disqualified from serving on boards of organizations. And there are various types of exposure or notification of the beneficial owners, the people who are in control of organizations. Okay, so this is where it's a bit hot off the press. In that you can see that I've made strike-through changes. Yesterday, these were draft regulations. Today, they are not. There's only one real change that has come where I've done some strike-throughs in the third bullet point. The list for voluntarily registered organizations, there's not a huge change in what has to be disclosed. Some small tweaks. And I think the forms are going to be changed and the reporting forms are going to be changed. But for those organizations for whom registration is now compulsory, there's additional organizational information and details that are required. Now, okay, all right. So the initial iteration of the regulations issued seemed to indicate that the onus would be on the organizations themselves to maintain the NPO Directorate's list of disqualified persons for boards. And one of the submissions that we made on this was that we thought there must have been some mistake, because in every other piece in the trust property regulations and the companies, it is those registration authorities which get the information from the Justice Department and which then populate those lists and which then feed down. So there's a public list of people who have been committed certain offences and who are not allowed to serve on boards, and then you would know. The NPO regs had it the other way around. In this latest iteration, they seem to have heard us and shifted it. The line which I've got in blue text is there's quite a lot in these regulations that isn't properly defined and that is unclear, and that in these final regulations, despite our commentary on this, is still unclear. So, for instance, they now say that information on the persons who own, control, or direct the activities of what they call high-risk NPOs. High-risk NPOs is not defined anywhere. We don't know if by that they mean compulsory registered NPOs, nonprofits, or whether they mean another category of higher risk. No indication. Including senior officers, board members, and trustees should be made publicly available. That's in the regulations. We don't know how publicly. The regulations provide for a register of information on people involved in registered nonprofits that is open for physical inspection, and that the director may give electronic access. We're not sure on what basis the director might or might not. lots of clarity. And in fact, one of the submissions that we made, which hasn't been heard as far as we can see, is that our big concern with, I mean, public disclosure and transparency is all a wonderful thing, unless the work that you're doing is in a sector where there are people who need, for one or another reason, to be protected. And so we are hopeful that the NPO Directorate is going to be, that they, with the may and all of that kind of language that's a bit fuzzy, perhaps they're going to be open to being able to listen to requests to protect information where people might be in physical danger in some cases, if the details of who was on the board or who was involved or beneficiaries was publicly released. One of the important things to alert you to is that, remember, because previously non-profit organization registration was voluntary, if you didn't comply, and by didn't comply, we basically mean usually didn't submit your NPO reports, because that has until now been the sole measure for compliance. The only thing that you could be threatened with was deregistration, right? Now, because there's this category of organizations for whom registration is compulsory, they can't threaten that category with that, so they have introduced other sanctions. They were very clear that there would be administrative sanctions only. However, and look, to be fair, in the regulations, there is a process, and there's a notification, and there's a, we think you've done this, and will you please rectify, and time given. So they put all those steps in. But when you get right to the end of those steps, after the process of caution, reprimand, and directive, there is an ability now that sits with the NPO Directorate to restrict or suspend certain specified activities of organizations. We're not sure how. That's all quite unclear to us, and in terms of what powers. And my suspicion is that there will be, if organizations have the funds to do it, or anybody who will do it for free, that there possibly is going to be admin law litigation or cases brought on this provision in the future. Okay. So just drawing it back to the kind of people who are now disqualified, and this is going across the board from serving on non-profits. So they've been disqualified by court order, unrehabilitated insolvents, public regulation. They've been removed from an office of trust. They've been convicted of, and in the black box, all the lists of sorts of things that they can be convicted of, or else the Security Council of the United Nations has issued a directive declaring them to be a bad person in general. Those kinds of persons, the CIPC, the Master of the High Court, and the NPO Directorate is meant to keep a register, and then those sorts of people are not allowed to serve on your boards. Okay, I'm just quickly looking at, is anybody, I haven't seen if there are any questions that I should answer at this stage. Are we reserving? Chelsea, is there anything that you feel that I could answer? Thank you. Okay. So just looking at the Word draft, now final regulations, and the additional information. So if your organization is working solely inside of South Africa and is doing all of its work inside of South Africa and is not donating any funds cross-border, these bullet points do not apply to you. These bullet points only apply to organizations who now their registration is effectively compulsory, whether you're registered or not. If you conduct cross-border activities or do cross-border funding, you fall into this box. And then this is the additional information that's required, that needs to be placed on record and updated. So legal form and registration number, trading number, income tax ref number. The reason I'm highlighting this is because I often come across non-profits, particularly voluntary associations, because they can slip under the SARS radar, who have never yet registered as taxpayers. There are a lot of people, including people who do people's books, unfortunately, who assume that because you're non-profit, some people assume you're exempt from tax automatically. That's not true. And some people also assume that you're exempt from tax returns. Voluntary associations are legal persons in law who have to register as taxpayers, even if they're tax exempt. They have to have a tax registration number, and they have to file tax returns. And as anybody who is an organization that has employees knows, you have to get a taxpayer ref number in order to get UIF or PAYE or any of those other sorts of reference numbers and be able to operate. So just shooting that one out in case there's an organization in the room that isn't yet registered for tax, please do so. Because if you suddenly want to approach SARS for tax exemption, you will have to backfile a whole lot of tax returns if you haven't been registered. And also sooner or later, a donor is going to ask you for a tax PIN to show that you're compliant, and you won't be able to do that. Okay, enough of that. Some of the things that are in black are kind of things that you will just need to keep these records and be ready to update them. Type of control structure is something you're meant to be reporting on. Control structure is not defined in the NPO Act. It's not defined in the regulations. We don't know what they mean. Everybody who's reporting under this is now going to be making it up as they go along. Titles of subcommittees of control structure. Okay, so I suppose we could make that up. We could say we've got this many subcommittees and this is what they're called. However, I noticed that the regulations that came through yesterday, there were some forms at the back of them, and the form that came with the regulations says the names and ID numbers of anyone who's on any of these control structures, including subcommittees. I think that this is a bit tedious and administratively burdensome, and I can't see the point, unless, of course, they're going back with the high-risk organizations. Perhaps it would be relevant, but anyway, that's my commentary. The other things that they want these compulsorily registered organizations to record and to place on record is names of affiliate organizations, also not defined. We don't know whether affiliate organizations with whom you have agreements or just organizations with whom you associate in some way. Maybe all of NASCEE are affiliated to each other, no idea. Fiscal sponsorships is also something. Now, they do in the regulations explain what fiscal sponsorships are, but then they don't say in terms of, they don't say, well, you must put up your hand and say, I am a fiscal sponsor for these unregistered organizations, or these people are fiscal sponsors for our organization. It's not clear. Countries worked in, descriptions of activities, details of auditors if you are audited. Okay, so once again, these are applicable to you only if you now have to be registered. Okay, so let's just have a look at NPO next steps. All right, so the first question is, if you're not registered at the moment, if you're an organization, an NPC, a trust, or a voluntary association, and you do not yet have an NPO number, think about whether you need to register. Although the effective date of the relevant section of the NPO Act is 1 April, it does say that the minister is to determine a period within which registration, the mandatory registration for people who have to register is now required to take place. That period hasn't yet been determined unless it's happened in the last hour, in which case put it in the chat. So if you are registered as a non-profit and you are behind with your compliance, in other words, with your NPO reports, you may know that it's been 10, 12 years since the NPO Directorate cleaned up its register of non-compliant organizations. They are terrifically out of date. And this is because of political pressure put on the head of the NPO Directorate not to clean up the register because of fear of political fallout. And as a result, lots of organizations have got completely lackadaisical about it and just haven't been filing reports because there's been no consequence. Okay, so if you are registered and you need for some reason to stay registered, file your outstanding reports now. I'll deal now with the cleanup process. The other thing you might like to consider, and this is in light of the kind of reporting requirements and details, is if you are registered as a non-profit organization and that registration is serving no purpose, if there are no donors asking for it, if you're not in the compulsory category, if you don't receive any sort of government funding, I mean, this might be a good juncture at which to say, let's consider deregistering because it's not serving any purpose and it's just an admin hassle that we don't need. Once again, only applicable for those of you who are voluntarily registered. So if you are registered but are now fit inside this compulsory registration category, just begin collecting the information that's going to be required for the enhanced reporting for compulsory registered organizations. And then I think for everybody, we need to be having a look and being aware of this the disqualification grounds for governing body members. And I mean, it's a good idea anyway to run background checks on governing body members, but that probably is something that you should just be doing because of this, and it might give you a good excuse to start this quite healthy habit. All right. Okay, so just some of these bits are taken from a DSD slides, these phase 1, phase 2, phase 3. This is something they've been putting out and presenting to a lot of people. And this is their approach to deregistration. As you can see, they're doing it in a phased way, and they're dealing first, it's based upon date of registration. So if you were registered between 98 and 2012, then they're now in the phase of deregistering non-compliant organizations. Okay, so that was meant to have started on 1 April 2023. There is this register and updated indicator on the DSD database, the DSD website, and on our notice, in terms of our sums, only 9 organizations have in fact been deregistered in the whole of April and some of May. So we don't think it's happening very fast, but still get ahead and get those reports filed. Don't rest just because it does seem to be going at rather snail's pace. All right. Just a side note, so I don't know how many of you are aware of this conversation, but prior to and then mixed up somehow in the amendments that came through with the Octopus Act, the NPO Act has been through various iterations over many years of updates that have then been sent out and then withdrawn or half-baked or whatever. The other NPO amendment bill that was live and which we commented on a while ago, I think first commented on the end of the dying days of 2021. There seems to be a tendency to issue these things just before we all want to go off on leave and make everybody hysterical. But that NPO amendment bill has now been withdrawn entirely. I am hopeful that the reason for its withdrawal, I'm an optimist, is that the latest engagement that civil society had with DSD on that NPO bill was that the solid foundation of policy development in collaboration with stakeholders and with the sector hadn't been done before the act was drafted. Very strong arguments were made on that. I'm hopeful that those arguments have been heard and that the half-started, half-stopped integrated policy development that was happening will now gain force again, and that will happen before the long overdue amendment to the NPO Act for other reasons than the FATF ones will occur in perhaps not this year. Actually, we could have a break this Christmas. That would be excellent. In terms of the NPO regulations, which were yesterday not yet finalized, I give them 4 out of 10 on a score. That's my subjective score of them. In terms of how they rank with the other regulations, definitely bottom of the class, sorry. Okay. Just for those organizations who are set up as non-profit companies and who therefore are subject to changes that have happened to the Companies Act, also in response to FATF. You see why I call it an Octopus Act. It keeps spreading its tentacles. As far as they hit non-profit companies, the beneficial owner provisions come to land at members in the most significant way. So up until now, you have had to keep a membership register, and that membership register actually has had to be a matter of public record. The regulations now say that has to be kept up to date within 5 days of any changes. The submissions that we made to in terms of these draft companies regulations were basically, are you mad? Organizations which have huge membership lists, the ability to update those whenever any one of those members changes the email address or physical address within 5 days, it's just not possible and it's not going to happen. So the submission that we have made is that this should be dialed back to something more sensible, like once a year perhaps, which is when organizations should at least update, organizations would have members, need to update their members register at least annually so that they can be sure who's able to vote at their AGM. So yes, there's new prescribed information that has to be kept in that members register. And that members register, in fact, the other interesting development is that when you file your annual returns with CIPC, which is needed to stay up to date and registered as a non-profit company, that members register has become something that you now need to file with your annual returns. The CIPC keeps an updated list of disqualified directors, and there's meant to be an automatic process in which if a director who is disqualified pops up, and I think the CIP systems that are already existing will be able to cope with this, if not now, probably shortly. The draft companies regulations did put into writing some of the existing CIPC requirements and practices in terms of reporting. So they've always had this very unrealistic idea that one would be able to report direct changes within 10 days. They've now put that in the regulations. We have said to them on that, also really not possible and never seen it happen, that all of the required information and documents for director changes could be assembled and lodged within 10 days of the change. As I said, these companies' regulations are still in draft form. We haven't seen the ones. Apparently, I've heard that once the commentary was closed, that the regs have been finalized, but I haven't seen the finalized version yet. Okay, here's the other type of legal entity that might be in this room, and that is if your organization is set up as a trust. Trusts are governed by the Trust Property Control Act. The first impact on the Act was the expanded list of disqualified sorts of persons. Now, in terms of trusts, there's an interesting angle here in that they have defined in the Trust Act beneficial owners, so people ultimately in control, as including the founders, the donors, so anybody, any organization or person who is listed on your trust deed as founder or initial donor, and then also the people who control the founders. So sometimes trusts are set up with another company or another organization, non-profit or for-profit, that is the initial donor or the founder. They now want you to have the detail of, for instance, all the current shareholders of that founder, or all the current board members, if a non-profit, of that founder. And this information needs to be recorded and updated with the Master of the High Court. So in terms of the regulations that came out for trusts, these are, we think, quite sensibly structured in that they've said that there is to be, in terms of the list of disqualified trustees, that is to be in electronic format, and anybody in the public is allowed to access people who are not now allowed to hold office as trustees. That's useful and probably as it should be. However, they've taken a slightly different tack, significantly different tack for trusts in terms of the prescribed information for what they're calling beneficial owners. So in other words, trustees, beneficiaries, if there are named beneficiaries, founders, people who are at the very bottom and in control of the founders. And that is that these lists of detailed names, date of birth, passport number, addresses, contacts, certified copies of passport or ID, those details must now be kept by trusts, and they must be uploaded and notified to the Master of the High Court. But they've provided for a procedure where only registered users and trustees can access that information. So they're not proposing public access to that information. And I think in terms of the Master of the High Court and the way trusts are, there's just a greater awareness and recognition in that structure of privacy and confidentiality rights and those sorts of sensitivities, particularly around trusts. There is an ability given in the regulations for designated officials to be able to search those databases, though. So if you're part of the NPA, Police Intelligence Services, SARS, you will be able to get in and search those otherwise private details. There is a test version out for organizations which are registered as trusts in terms of getting that information in. It's a very simple electronic database. We're worried that at the moment it's maybe not secure. And it's obvious that the electronic systems of the Master of the High Court, such as they are, and they aren't great, if anybody's got a trust knows, they will need to be upgraded in order to deal with things like security, in our view. Okay, I'm going to jump quickly. I don't know how we're doing for time. Oh, good, we're doing all right. I've been racing through. Hope I'm not going too fast. You will have seen, I think, information on this already. I think it might even have been at the end of the notes which I sent to you, which is around 18A receipt requirements. So the bits that I've highlighted in yellow on this screen are the additions to your 18A receipts. And that's, so if you are issuing a receipt to somebody, a person or a commercial company in South Africa who requires a tax deduction, you need to put these fields onto your receipt, collect this information, and one of the reasons you're collecting this all of this information is because the next phase that's coming with SARS is that organizations are going to have to actually report on this. So there've recently been regulations issued, and this is around, they were issued, a draft notice was issued, not a regulation, sorry, a notice was issued by SARS for commentary on the 12th of April 2023. We've already put commentary in on it. I think the period for commentary has closed on it finally. And this is around what adding 18A organizations to the lists of types of entities which must submit third-party returns. Okay, so this is about an organization being responsible to report transactions to SARS that affect other people's tax returns. So if you think about it, at the moment, medical aids do that, banks do that, investment brokers do that. When you go as an individual to lodge your individual tax return, those fields are often pre-populated with whatever medical aid you paid, whatever interest you've received from a bank, your investment income. And that is because these other institutions are collecting this information, are collecting it against your tax reference number, and are feeding that information through to SARS. Okay, so the idea now is that that sort of virtuous circle for SARS is going to also work in the nonprofit sector. And added to the list of types of entities and organizations which must now file third-party returns are organizations which have 18A status and which have issued 18A receipts within the relevant period. Okay, so just because you've got 18A status, because of the type of work you do, doesn't mean you have to issue 18A receipts or would necessarily have issued 18A receipts. If all of the funds your organization receives are from overseas donors or from organizations which are themselves tax exempt, then you don't need to issue 18A receipts. You can issue a normal receipt saying thank you very much, because they don't need to get a tax deduction because they're not taxpayers within the South African system. All right. So, and I think that this is a point that's quite important to make, because you could find that if you don't have to issue 18A receipts and you can dial those back, that you might not have to file this additional report. Okay. The other new category of organization that has to file third-party returns is trusts which are established or managed in South Africa and which vested an amount in a beneficiary during the relevant period. Now, before everybody goes, what, this is double doing for trusts who are also 18A. Yes, a donor trust who has 18A status will have to file 2 sets of third-party returns, but they're in respect of different sorts of transactions. So the 18A receipt return is, this is all the money we've received in the year for which we've issued 18A receipts. The trust return is, this is the money that we have given out to named beneficiaries during the year. Okay, so it is only 18A donor trusts who will have named beneficiaries. So if the organization is a trust and it has 18A1A status and is a doer and not a donor, it's not affected because it's not vesting funds, it's not donating funds out to beneficiaries. Okay. I'm going through this quite fast. There will be more detail coming on this, I'm sure. At the moment, SARS is doing a very nice testing phase. They are trying to make sure their systems can cope. They're trying to tweak things. They are being very open. They are working as they usually do, very happily with the sector. There are a couple of organizations, maybe some in this room, who might be part of their pilot project and who are helping them test their systems. The first third-party returns for organizations which are affected are only due end of Feb next year, and they're only in respect of the period from August 23, so starting August this year, through to Feb 24. Important to note, I don't think I put on the slide, that at the moment the notice doesn't impose any sorts of penalties for non-compliance. SARS is they're not looking to punish people in the initial phase for not being able to do it quite right or not have their systems in order. They're going at it in a very user-friendly way. The intent behind all of this is to connect the dots in terms of 18A funding. So up until fairly recently, up until about 3 or 4 years ago, anybody could claim an 18A tax deduction with their tax return and could make it up, could make up the name of the organization, could make up a reference number, and unless they were audited by SARS, SARS had no way of knowing whether that 18A deduction claim was real or not. Then SARS has now more recently been entering fields that have to be filled in, and as a result of that, a whole lot of people who were making up numbers, maybe even for giving valid deduction claims, but were just using any old number, those have been bouncing. And there was a whole season, some of you might recall it, when suddenly a whole lot of your donors were going, eek, why can't I get my 18A deduction? And it would be because they had your old 18A ref number, or they were putting in the NPO number or something like that. Okay, so it's been a bit of a process from SARS in terms of connecting the dots, but the idea is there's been a lot of fraud going on in the 18A sector, people getting away with tax deductions, not actually giving the money. And so now SARS wants to know not only that the details that have been lodged by the taxpayer when claiming the return, claiming the deduction are real details, but they also want to know that the organization named has actually received the money. So that's the circle that's being closed with these third-party returns. Now, the practical thing that I just want to put across your radar is that when this third-party return is uploaded, it's in a specific format. I think most organizations in the room that have to do this, whether you're keeping this information in an Excel spreadsheet or in your financial package, there should be an ability to download or convert into a format called CSV, which will then be able to be uploaded. However, when you upload into CSV, it's going to be important that all the fields and the columns are named exactly as they are in the SARS format and are all in the right kind of order. I have got at the moment 1 or 2 organizations that are in my filing cabinet who are part of the testing process, and out of that we are going to extract what those fields and headings and things should look like. Details I know, but they're going to be important, because I think that if you can, from August, start collecting it in a spreadsheet or in a system which has it exactly right, it's going to make it much easier just to upload it when you need to do that. So watch the space for details. We will be sharing that as soon as we know. Okay, and then that's it in terms of the formal stuff.